Welcome everybody, both speakers, panelists, and also guests. I'm very happy to welcome you today to this fifth and penultimate seminar in our six-part series of online meetings concerning a framework treaty on business and human rights, interdisciplinary insights. My name is Claire Methven O'Brien. I'm a Baxter Fellow and a lecturer at the University of Dundee in Scotland. And I'm the convener of the University of Dundee's new Business and Human Rights Network, and also its newly established LLM on business and human rights. First, I would like to gratefully acknowledge the financial support of an interdisciplinary incubator grant from the Social Science Research Institute of the University of Dundee for their support of this series. I should also now thank this group of leading international experts from across social science disciplines who are, I'm very happy to say, giving generously of their time, knowledge and insights today to serve as our panelists. And I'm very happy to welcome Professor Larry Catá from Pennsylvania State University, Professor Dorothée Baumann-Pauly from the University of Geneva, Dr. David Birchall from London South Bank University. I think this is great, Larry. You instituted the practice of waving. This is nice. Dr. Jernej, Letnar, Černič. Apologies for pronunciation. Černič perhaps is more correct. You can correct me. From Nova Univerza in Slovenia. Dr. Sorcha McLeod from the University of Copenhagen, Dr. Miho Taka from Coventry University in the UK, and Professor Rachel Anderson, if she's not already with us, will be joining from the University of Nevada. And through their input, we aim in this series to advance interdisciplinary, at least to attempt, and to hopefully advance interdisciplinary dialogue in the field of the Business Human Rights Treaty debate, to explore key questions such as questions that will highlight and explore the relative merits, possibly, and demerits of a framework-style convention on business and human rights along the lines I have proposed over the last years, as compared to the text and approach that have emerged so far from the current Intergovernmental Working Group on Transnational Corporations and its process. And just for context, briefly, in case some of those listening are not fully informed or immersed in that process, of course, and its history, of course, in the United Nations, there have been attempts to define international standards addressed to business and their human rights impacts over several decades, going back at least as far as the 1970s with the Transnational Code of Conduct for Corporations initiative. In the 1990s, there was the UN Draft Norms initiative. Neither, of course, of these standards were ultimately adopted by states. Subsequently, in the 1990s, we had the movement towards corporate social responsibility, the Global Compact, as a UN CSR initiative, which incorporated principles on human rights, but of course, not directly enforceable in any way, very high level, non-specific. And in the wake of that initiative, of which, of course, the recently deceased John Ruggie was one of the chief architects, we have had the UN framework and guiding principles on business human rights, which he developed along with his team as special representative of Kofi Annan as Secretary General of the UN. This UNGPs being a soft law framework, which arguably, because of, in spite of their status as a soft law framework, have become a widely referenced benchmark in relation to state duties to protect against business-related human rights abuses, corporate responsibilities to respect human rights, to be operationalized through due diligence, and also in relation to the need for effective remediation of business-related human rights abuses for victims. In parallel to that process of the sort of internalization of the UNGPs by some companies and by other governance actors, entities in the financial sector, development organizations, and so forth, by states through national action plans. In parallel, there's been a process since 2014 to develop an international treaty on business human rights, launched by Ecuador and South Africa, but so far has, in some senses, struggled to make progress. Some important advances have been made in clarifying elements of that proposed legal instrument, but key actors have remained, key geopolitical actors have remained outside that process, completely and apparently opposed to it for a variety of reasons, while from a sort of technical legal standpoint, and arguably, but I would say there are also questions of the sort of feasibility of what is proposed there as a legal instrument. So can we sort of move beyond what in some ways is a stalemate currently? I have suggested that a framework instrument that provides a platform for the development of more specific standards that address different value chains, different sectors, perhaps different geographies, which articulate an international set of oversight institutions and general principles with the existing sort of governance constellation of business human rights, may be a more fruitful way of proceeding, and that provides really the focus and rationale for today's seminar. Of what I really hope we will be able to explore with this panel is how some of these key existing elements of the business human rights governance constellation could or perhaps be articulated, in a more or less formal way with a framework instrument and its organs and institutions and processes. So where we have national action plans on business human rights, where we have national contact points in the context of the OECD, where we have already quite elaborated standards and institutional arrangements around conflict minerals. Would it make sense? Does it make sense to try to think how could they be, organized in relation to a UN framework instrument rather than sort of proceeding on parallel tracks? Can we achieve a more sort of holistic overall arrangement here where we do sort of succeed in addressing the governance gaps created by globalization rather than having lots of things sort of operating in their own orbits? So that is, I think, probably sufficient for context and background for participants. I hope so. In terms of housekeeping, I should say these seminars will be recorded, and do check the University of Dundee Business Human Rights Network webpage in the next weeks to access those recordings. They're not available yet, but that's where we will post links. Today's seminar will consist of what we're calling lightning contributions from our different speakers, so around 6 to 8 minutes each. And after those, at the end, there will be time for questions from participants. So please do put your questions either in the chat, type them in the chat, or when the time comes at the end, do raise your hand and we can call on you to ask your question in person. Now, I think with that, I will start by turning Jernej to you, if that's okay, to share with us a little bit your insights and knowledge around national contact points in the OECD, both their strengths and weaknesses, their main functions at the moment, and how, would it make sense to think of trying to connect them with a UN framework instrument? Thank you.
Thank you very much, Claire. Thank you for the invitation. It's good to be at this webinar with such distinguished friends and colleagues. Now, my presentation, my brief introductory remarks will concentrate, as you said, Claire, on the lessons from the national contact points, both strengths and weaknesses. But let me, because I really liked your introductions, the challenges we face in business human rights in the last decade, and also what I have seen from my work in the last years here in Central Eastern Europe, there are quite many challenges, how to go about it. I mean, what should be the aim of any global normative instrument in a business human rights? Should it be, to strengthen UNGPs, or perhaps, to provide access to remedy for rights holders, or if you want, victims of business and human rights abuses. Particularly here in Central Eastern Europe, there are quite many challenges. Some of you would know that only 4 countries out of 24, 25 have adopted national action plans: Poland, Czech Republic, Lithuania, Slovenia. 2 of the countries have very short subchapters in their national human rights strategies, Georgia and Ukraine. And besides that, there is really not much going on. Most of those states have also not participated in the negotiations, any of the negotiations on the UN Business Human Rights Treaty in Geneva. I think the sole exceptions are Russian Federation and Azerbaijan, which took part in, I think, 4th and 5th negotiation rounds. But there are many of the challenges. They are very much present in Central Europe, particularly having to do, how to move forward in business human rights. How to ensure that rights holders, have their voices heard, and of course also that companies do not feel, that they carry this very heavy, burden to conduct, to comply with regulations. Just to put it shortly, here in Central Eastern Europe, most of the governments are very much inclined, to promote foreign direct investments, free trade, and they're very much against the regulations. So having said that, I can see from the ground that I mean, challenges are very much present here, because the alleged violations and abuses by the companies, but also particularly by state-owned enterprises in these regions, they almost never get addressed, or states would never, be tried in the courts for, failing to comply with their positive obligations to protect individuals from adverse business impact. So, having in mind this context, perhaps a bit different than, in Northern Europe, or perhaps in global North. Let me just give you some points and some strengths and the weaknesses of national contact points. Of course, in the global normative frameworks, there are not very many of direct access to remedy for rights holders. And OECD guidelines for multinational enterprises, which are soft law document, they are part of the declaration of OECD on investments. They provide kind of access or remedy for rights holders. Perhaps more progressive commentators would say that OECD guidelines, they are quasi-legal document, and national contact points as enforcement bodies, quasi-judicial bodies. Not sure if I can agree with them, but certainly they provide an avenue for victims to have their complaints heard. Besides, for example, tripartite declaration on the ILO, they provide one of the few global mechanisms for victims to access justice in the case of violations of labor, human rights, environmental concerns. What are the strengths of the OECD guidelines? For sure, the strength is that they exist. That they provide this access to justice. They're also quite broad in scope. They range from environmental rights, labor rights, human rights, anti-corruption standards. So in a way, they set out quite a robust, substantive framework for complaints being made against companies concerning their activities outside their seat of registration. One could also say that in a way, they bring about a change, a positive change in business human rights. We all know that there are not many positive stories from a rights holder's perspective, and the guidelines and national contact points they provide one of the best examples in this framework. Now, if you ask me if they can provide a justice to victims, well, this is another matter. And here, perhaps to answer your question, Claire, how national contact points could, complement the existing frameworks, or even the forthcoming frameworks, either your proposal or the proposal which is negotiated at Geneva. Well, the first thing would be to address their weaknesses, and for sure, one of their weaknesses is that they have very limited geographical scope. They're part of OECD, which it's an organization which only includes, mostly includes countries from global north, plus some Latin American and Central European countries. So they were very limited in scope. Secondly, they are very weak in providing redress to victims. Many of the articles and research which have been made in the past years, the common conclusion of all different reports and academic articles is they cannot really provide, effective redress for victims. Also, the third weakness, which I also find is that how can victims from the same place where alleged violations occurred, how can they expect, when they bring a complaint before, for example, Australian or US national contact point, could they expect that both of national contact points will treat their complaints in specific instances in the same way? And the answer is not at all, not really. There have been many cases in the past where, for example, those two NCPs deliver totally different results in the same, concerning the same events. So one has to be really careful when addressing that. And then perhaps the fourth and perhaps the most important concern, at least in my opinion, is how to ensure their independence and impartiality. Most of these national contact points, which, as I said, are enforcement body OCT guidelines, they are located in the ministries of economy, industry, and as such, they cannot really, comply with these requirements of independence and impartiality, which rights holders demand from enforcement bodies. Not many of them, they have, oversight mechanisms. Most of the NCPs in the Northern Europe, from Denmark, Netherlands, Norway, in those national contact points, they are, multi-stakeholders. There exist multi-stakeholders oversight body, but in other jurisdictions they don't really exist. And fifth weakness of the guidelines at the moment is that there exists very divergent practice in their structures and the functioning. The national contact points in the countries of the Northern Europe, such as Netherlands, Denmark, Norway, Sweden, Finland, France as well, they are more or less functioning quite okay from the point of requirements of the access to remedy requirements under UNGPs. But if you move east, if you move to Latin America or to Central and Eastern Europe, the practice is quite different. Many of these national contact points are not functioning. They are not existing. The government really don't want to put the funding and the personnel behind them. I can tell you this from my personal experience as a person who is serving at the advisory body of the Slovenian national contact point, which so far only dealt with one case last year. It was thrown out on the procedural grounds concerning activities of one British extractive industry corporation in eastern Slovenia. and the government really didn't want to involve stakeholders. So there's not really commitment by the government, which is also seen from lack of national action plan in global south. So if you ask me, what is really needed to improve this framework in order to be viable option to serve either under your proposal or existing proposal at Geneva, I would say, I mean, the whole system has to be strengthened. And not only at the national level, I really expect a lot from the OECD Investment Committee and OECD state parties to finally put the teeth in the OECD guidelines mechanisms to make them binding and to ensure uniform application across 37, 38 member states. And of course, initially, just to make sure that all member states of OECD, they have functioning national contact points where victims can bring their complaints. I think this is really necessary in order to offer or to employ the national contact point systems under OECD guidelines as a viable tool for the enforcement of any global business and human rights treaty.
So would it be correct to say the implication of your what you've communicated there about the NCPs and also about the variable geographic implementation uptake of UNGPs does weigh in favor of having a global instrument in business human rights? Potentially it can strengthen, but I also wonder, and maybe you could be very brief, just in the interest of time, do you think this would help, extrapolating from the experiences of other international human rights instruments? Of course, we have, Convention on the Rights of the Child and so on. Would having such a UN-based standard, do you think it would help to even out the discrepancies, the current geographical discrepancies? Yeah. Would it be a significant factor for those countries who haven't, so far sort of taken it by the bull by both horns?
Yeah, definitely. I think any international instrument would bring about a positive change at the domestic level. I think one of the challenges many of us have recognized in the last years is that domestic systems in many of the countries, that they're not able or willing to address these concerns concerning negative business and human rights impacts. And for sure, OECD guidelines framework as a framework, it could be, translated to the global framework. Of course, if these basic conditions of access to remedies are accepted, because OECD guidelines are often seen, as just last time one of my colleagues just mentioned that they're seen as it's kind of imperialistic, colonialistic tool for global North to educate, uncivilized global South. So I agree with you, Claire. The international instrument is necessary to provide incentive, but also encouragement for domestic systems to develop more robust domestic responses to business and human rights concerns.
Thank you so much, Jernej. Sorcha, if I could turn to you, as regards private military security contractors, of course, this is an issue which has separately attracted norm making and concern, and there are already sector-specific initiatives which embrace private entities, suppliers of those services, along with government, civil society. What are your experiences in that realm? Tell you or suggest to you about issues of multi-stakeholderism in the context of a broader scope UN instrument, and also this question, which I think is an interesting one, of how sort of sector or value chain initiatives might be, brought under the umbrella of a sort of broader spectrum UN treaty.
Yeah. So thank you, Claire. It's lovely to be at an event at the University of Dundee. This is where I did my undergraduate degree. So unfortunately we can't be there, but it's wonderful to be at the event. So for those who are not familiar with the private military and security industry, let me just give you a kind of quick snapshot of the regulatory framework that exists, essentially in parallel but connected to the broader business and human rights initiatives. So in the aftermath of the interventions in Iraq and Afghanistan and the human rights issues that came out of those interventions tied to private military and security companies, the international community decided to specifically regulate the sector. The thinking behind that was that somehow the private military and security industry was different, and that it ought to be regulated in a particular way and in a different way from other businesses. Now, I was involved with the creation of the International Code of Conduct for private security providers and the Montreux document for private military security companies in armed conflict. And so what we have is a very specific set of regulatory initiatives for this industry. Now, they mirror the business and human rights initiatives so far in that they are soft law. They are not compulsory, they're voluntary. There's no requirement for a company to become a member of the International Code of Conduct Association, for example. The Montreux document explicitly says it doesn't create any new rules, that it is merely bringing together the existing rules that apply for states in relation to the contracting of private military and security companies, and it provides what it calls good practices that may be instructive for the industry itself. So the Montreux document was then followed by the code. Now there is a little bit of an overlap, because whilst the code doesn't mention the guiding principles, because the code was finalised in 2010, so before the guiding principles were finalised, nevertheless it does in fact refer to the protect, respect, remedy approach. So there's already a link there, there's already a connection. Now, this code in one sense, and I think one of the points that was made already is that I think it was Jernej said that it's good that it exists. You know, that yes, because we certainly do have private military and security companies paying attention to human rights standards. So that is, you know, ostensibly a good thing. The difficulty with the regulatory structure that we have is, as we've already said, it's voluntary. When it comes to the code, we have only 7 states that are actually active participants and members of the multi-stakeholder International Code of Conduct Association, and the code itself is somewhat problematic. It only focuses on whilst human rights and international humanitarian law are supposed to be included in the scope of the code. In reality, the code explicitly mentions, I think, about 6 different human rights. So it talks about the right to life, the right to be free from torture, talks about slave labor, child labor, human trafficking, discrimination. And it's had the effect of sort of funneling the attention of these companies into these very specific human rights areas, and they don't really think about human rights in a broader sense, and they don't really understand the indivisibility and interconnectedness of human rights. So that's one problem with the code. The other problem with the code is that the geographical scope is extremely narrow. It applies to what are called complex environments, which doesn't have any legal meaning, but it essentially applies to situations of armed conflict and areas where the rule of law has been damaged by humanitarian or environmental disaster. So the reality is that private military and security companies are operating outside of these types of situations on a very regular basis. We just need to look at what's happened during COVID. We've seen private military and security companies moving into new spaces. So they've been guarding testing sites, vaccination sites, quarantine hotels. They've been taking temperatures and medical histories. They've been doing all sorts of new things as a consequence of the pandemic. And the International Code of Conduct for private security providers simply would not apply to companies operating in many countries and carrying out these sorts of activities. So we've got that definitional problem. The third problem is that the code envisages a certification approach or an auditing approach, and there are some very specific audit standards for the sector. So we can look at PSC1, we can at ISO 18788, and there are others. Now, certification or auditing per se, or on the face of it, is not necessarily a bad approach. The problem we have here is that we have private companies that are charged with carrying out these audits, and they are competitive, and they, of course, are competing with each other to get the contract to carry out the certification. And the research that I've done shows that there's significant difference in quality of the audits that are carried out by these companies. Now, one of the positive things about the audits is that the audits are two-stage. So the audits take in, if you like, a desktop part, which is where the auditors go to the head office, the headquarters of the company, and carry out a paper-based audit on the policies and processes. So that would include a human rights policy, it would include their human rights due diligence, etc. And then the second phase, if they get through that phase, the second phase is that the auditors will then go on the ground and look at how the companies are complying with those policies and processes in practice. So there's a strength there that you know there's a thoughtful element to the certification process, but the way in which the audits are being carried out is definitely open to criticism and is problematic. So I would say that those are sort of some of the key problems that we have with the regulatory structure for the industry. And as I said, I think during COVID we've seen that the problems with the regulation of this industry have been exacerbated by the pandemic. And I think if we also if we look at what's happened in Afghanistan, one of the things that the companies and the regulatory, the MSI, the Code of Conduct Association talks about, they say, oh, we really need to look at labour issues and labour standards. Yet during the pandemic, the private security industry has had one of the highest mortality rates. This is an industry where people were on the front line. They were not properly looked after in terms of having personal protective equipment. And in Afghanistan, we see that the contractors who'd been subcontracted by particularly companies from the global north were left behind in Afghanistan. That they were not, that we saw the UK and Australia saying they are private contractors. We do not owe them any obligation. We did not employ them directly. And I think these two situations have really highlighted the gaps and the difficulties that we have with the existing regulatory framework. And I think I want to stop there, and I think I can expand on anything in questions.
Yeah, great. Thank you very much, Sorcha. I mean, just very quickly, one follow-up question is, these issues about the weakness of certification and audit, of course, are you can almost say general. They're systemic, and they don't affect only the PMSC's domain, well documented in relation to apparel, for instance. And I know Doro will have some things to say about it, but I just wanted to know from your perspective of your expertise in PMSC, what would you see as being the sort of possible solutions or measures which can mitigate these issues? Is it stakeholder voice? Is it transparency? How do you, have you thought about how to reconfigure the governance of the code and its associated institutions to fix some of these weaknesses?
Yeah, well, I should say one of the sort of positive elements that I think it distinguishes the auditing and certification for the private security industry is that the International Code of Conduct Association has an oversight and governance role. So the certificate of certification, the audit certificate is not the end of the story. So for a company to be said to be in full compliance with the code, it has to have the audit certificate, whatever standard it chooses, whatever auditor it chooses. It then also has to meet the additional criteria that the ICOCA, the International Code of Conduct Association, imposes. And so there's an additional level of oversight than just simply taking the audit certificate at face value. Now, having said that, that is also a weakness of the system, because the auditors say the ICOCA is not a recognised standards body, and therefore it cannot question the veracity or the quality of the certificate. So you can't look behind the veil of the audit certificate, and you can't actually look and see, the ICOCA can't look and see whether this was a good audit or a bad audit, if I can put it in those binary terms. It takes somebody like me and my colleagues to come along and say, well, when we actually look at whether companies have human rights policies, whether they're doing human rights due diligence, whether they have a corporate level grievance mechanism, then we can see that there's a clear there are clear hierarchies of quality when it comes to auditing. So I think what we can conclude is that as I said at the beginning, auditing in itself is not, on the face of it, a bad thing. It has potential to be a good thing, and it has the potential to ensure that at least in this case, private military and security companies are complying with human rights standards. However, all of the backup behind the audit has to be in place. So it means that ICOCA has to be able to look at whether the audits are in fact being properly carried out, and not just accept at face value another organization's standards and say, well, we just have to say tick, you've got that certificate, but let's look at what we can actually make you do. So potential, yes; reality, different.
Okay. Thank you. Thanks a lot. Miho, Taka, some of your work focuses on conflict minerals, and we see many sort of similar elements. The regulatory technology, if so to speak, is sort of encompassing some similar elements in conflict minerals, certification, custody across the supply chain, and so on. And I wonder, based on your work, how effective is this approach? And do you see that the specificities of a specific problematic like conflict minerals lend themselves to sort of unique standards, unique institutions, or can a sort of UN human rights treaty prescribe similar or the same approaches for companies to implement that span across all commodities, value chains, and so on? Because the way I see it is that from what I've absorbed about conflict minerals is just how sort of unique and complex the regulatory approach is and has to be, so because it's modeled around that one sort of value chain. And it's quite hard then to see how very specific standards on due diligence could apply broadly, if that's clear. But anyway, your insights, please.
Okay, so I think I want to share a few slides because I've got some pictures. Yeah, so I think I start from this slide with the supply chain. So I hope I can cover what you asked. So at the moment, we often talk about the 4 minerals: tantalite, tin, tungsten, so-called 3 Ts, and the gold. But we have a specific challenge in these minerals. Although the demand is increasing because they are technology minerals, so we need more of these. However, they are often from artisanal mines, that's so artisanal and small-scale mining, and some of them, I don't know if my slides are shown. Yeah, okay. So we often see this kind of picture of armed groups, etc., hanging around. So from this to whatever our commodities, smartphones or laptop, the supply chain is hugely complex and have got many layers. So the effort has been focusing on particular point. So that is from the mine to the refiner or processor. Because once those minerals are processed, we cannot find out where these commodities or ores are from. But coming back to the human rights framework, I think it was significant in 2 ways. So one way is that human rights framework, and particularly about due diligence, the idea of due diligence, basically implies that it is no longer good enough to just look at your own direct suppliers, often like first or second tier supplier, but you need to look at, because you have to look at your business relationships. So you have to look at the entire supply chain. So that was the challenge because of the complex supply chain. The second point is that obviously the human rights framework has led to other regulations. So the most famous one is the US Dodd-Frank Wall Street Reform and Consumer Protection Act, which has the conflict mineral clause. Recently, EU also enacted similar regulations. So the both cover those 4 minerals, but the EU also covers not only the Congo and the surrounding area, but from other conflict affected areas as well. So it can be from Colombia, etc. So the 2 are the main points as a paradigm shift in responsible supply chain management for companies. So since then, we have several different schemes. I can say maybe 3 or 4. So one is the guidelines, such as OECD due diligence guidance for responsible supply chains of minerals from conflict affected and high risk areas. So that provides particular guidelines for companies. And the second is certification or verification of standards. So it's about labor standard, environmental standard, etc. Again, there are several of them. And the third is the chain of custody. So using the independent third-party audit and probably including risk assessment and etc. You can certify the origin of the ores. And often it is focusing between the mine and up to the processor. recently some schemes use blockchain technology as well. So, and the fourth is similar to the third one. So closed pipe supply chain, or you can call it one-stop shopping. So you have a particular set of miners, traders, etc. So that it's for the companies who are using minerals, you can source the minerals from that particular closed pipe supply chain, so that you are sure that who are the miners, who are the whatever traders in between, etc. So that you can find the origin. Now I can show you two examples. So I have conducted a scoping study in Rwanda some years ago. So I give you two examples. The one is the certified trading chain to provide standards. But what I found out is, yes, they are doing it, they are certified. However, the company who is doing it was not willing to continue because it can't help sell the product. And of course, using, so yeah, basically you still have a competition from whatever other countries. And this certification doesn't help them to access to better market. Now the second one is the chain of custody. So International Tin Research Institute Tin Supply Chain Initiative. This is a bag and tag. So at the point of a mine, you will bag it and then tag it with barcode so that you can identify where the particular ores are from. And I want to show this picture because I am in this picture and went into the mine, but it's this kind of mine. There's no health and safety whatsoever. And the water that is used in the mine is just going onto the ground. So there were no other standards. And another thing is that they will accumulate certain amount of ores in a bag, and somebody comes to bag and tag once a week in this case. So of course it is still possible to add whatever ores from other places. So there's a question of how credible is it? And also for the company who is using this bag and tag, there's also, I think for any certification, there's a cost. So for those companies to use this bag and tag system, they have to become a member so that they can get these tags and barcodes. So when you are facing competition from other countries, etc., again, it's not really commercially attractive for the company. So there's those issues. Reflecting all what I have been looking at, there are certain, I think, improvements in technology, etc. But coming back to the points that I did a scoping study in Rwanda, the reason was these schemes were often piloted in Rwanda or particular areas where there's a security, even in the Congo. So although we want to address human rights issues and a conflict, in order for these schemes to happen, you need a certain security already. So it doesn't really help addressing the human rights. So of course, other people also mentioned access to remedy, which isn't there, but not only the access to remedy, but from the beginning, you cannot implement these schemes in an area which is highly affected by conflict. So that's a kind of issue. Of course, it's very difficult to monitor, implement in those challenging environments. So how can we actually effectively implement this is a big issue. And another issue, I want to refer to the first speaker about the impartiality. So again, this is an issue because for those who can join the closed pipe supply chain, etc., they have a particular contact or access to companies, etc. But for others who do not have access to those companies or organizations, they are excluded. So these schemes are not very fair, or there's a lack of fairness, or I wouldn't say this is impartial.
Thank you very much, Miho. Maybe I could just turn straight to Dora Baumann-Pauly to ask if there are some points of contact, some resonances, but also maybe some divergences in relation to your own work on multi-stakeholder initiatives, in terms of which has been very interesting, I think, in identifying some of the factors which may be drivers of effectiveness in the context of MSIs.
Claire, thank you so much for having me. It's wonderful to see colleagues who I haven't seen for a long time due to the pandemic, and not just seeing, but also hearing from them and exchanging. My comments will be more on a meta level. I greatly enjoyed Miho's deep dive into conflict minerals and Sorcha's thoughts on the International Code of Conduct for Private Security Contractors. Yet I want to take us back to your original introduction, where you, I think, did a brilliant job mapping the very fragmented nature of the business human rights field and the currently patchworked corporate accountability mechanisms that we have. What we are trying to achieve is a level playing field, I think, for companies and corporate accountability. And I hope that eventually we will have a number of overlapping mechanisms. So currently I see it as a fragmented field with many gaps in between where we don't have corporate accountability. But I believe instead of trying to find the silver bullet, we should embrace this diversity of our field of different mechanisms and figure out how can they be overlapping so that there are fewer gaps. So with that metaphor, I also want to respond to Sorcha and Miho, and that I fully agree with their hesitations to fully embrace these MSIs and these so-called voluntary initiatives. But let me start out with the following argument. I don't think the dichotomy of voluntary and mandatory is particularly useful. And since we are currently, at least in Western Europe, putting all our bets on mandatory human rights due diligence, and I think too easily dismiss these so-called voluntary initiatives, it's important to reflect back on what's truly voluntary, what's truly mandatory. On the voluntary side, I mean, these MSIs, of course, they don't cover all geographies and all companies, but the companies that are part of the MSIs, they're often deeply committed. And for them, compliance with the standard is not voluntary. It's mandatory. Once they've signed up, it's mandatory that they comply with that standard. On the mandatory side, I mean, we have now some initial human rights legislation that tells us a bit about how effective these pieces of legislations are. Miho mentioned the Dodd-Frank Act. We have a Modern Slavery Act in the UK, and I'm not too impressed by their effectiveness. So now you could say, well, the laws have not been very carefully designed. They don't really have the teeth yet. But for now, given the legislative processes at the national level, I think it's always the result of a political compromise in the end. And on modern slavery, we only currently have a requirement to report. And I have spoken to a law firm recently in the UK, and the law firm told me we advise our clients to report that they have nothing to report, because this way they can tick off the reporting requirement without exposing themselves to any risks. So for me, this is the peak of hypocrisy. So the mandatory human rights due diligence requirement will not solve anything, everything either. So with this, I think we should embrace the patchwork nature, but figure out how to close the gap and support an overlapping landscape of different corporate accountability mechanisms. And for me, multi-stakeholder initiatives are part of that landscape. We shouldn't too easily dismiss them. And in this spirit, we've just published a white paper, and I show it here on the screen, seeking a smart mix, because I really think we need a mix of public and private regulations, and we need a smart mix that allows us to overlap corporate accountability mechanisms. And in this paper, I also make the argument with my co-author Isabel Glimcher from NYU Stern that we believe those multi-stakeholder initiatives are today more needed than ever, because as human rights due diligence becomes mandatory, a lot of legislators will need to figure out what is adequate human rights due diligence. So how do you define adequate? And since human rights due diligence in itself is not a standard that we can measure, we still need industry-specific standards that can be translated into metrics and means of evaluation. And for us, multi-stakeholder initiatives are one potential avenue through which such concrete standards can be developed. However, as I said, I deeply sympathize with the criticism or hesitations of Miho and Sorcha. I also see, of course, that many corporations are using these collaborative initiatives as a facade for actually not doing much. So we have to make sure that we don't embrace the whole category without actually looking behind the facade and introducing some academic rigor, I think, into the debate about multi-stakeholder initiatives, and define criteria and ideally a typology of multi-stakeholder initiatives that, at least in their structure, have a chance to deliver on corporate accountability. And in this white paper, we actually define a typology and criteria for valuable MSIs that can deliver and that can advance human rights in corporate practice. And certainly one of those criteria is that the initiative is of true multi-stakeholder nature, because there are so many industry-only initiatives that sort of loosely call themselves an MSI as well. So that's sort of the first hurdle that we think needs to be crossed. Then, of course, the standard, and Sorcha, that was one of your concerns, needs to be in accordance with international law. And then the standard, there must be a monitoring mechanism. It needs to be the compliance must be monitored independently. And if there's non-compliance with the standard, there also must be ways to enforce compliance or some penalties. And certainly there also must be transparency to understand what are those voluntary initiatives actually doing, and are they making progress, so that we can assess their actual effectiveness. And so with these criteria, we're hoping to introduce standards for multi-stakeholder initiatives, because they shouldn't become a safe haven, something that some civil society organizations fear with mandatory human rights due diligence requirements. Basically, the government says, well, if you're part of that MSI, you're fine. That's not good enough. Neither should all MSIs be dismissed, because some of them, I think, deserve strengthening, probably deserve also more resources so that they can reach their full potential. I think I stop here and let others react to this. Thank you.
Great, thanks, Doro. And I mean, you know, in your view, then, do you think it's sort of grandiose to imagine that maybe, you know, if there was a broadly defined UN level business and human rights instrument, that could provide a platform for a sort of formalized review or accounting exercise by means of which individual MSIs could be scrutinized in terms of their quality, their compliance with, you know, an overall set of principles or quality criteria? Would that be, you know, would that be valuable and appropriate for there to be such an exercise convened within the UN setting?
Yeah, I'm not sure if I'm in favor of a review rather than introducing those criteria as the good practice criteria for MSIs. And I mean, these criteria are not falling from the blue sky, but they're modeled off some existing MSIs. So they're not utopian, they can be implemented. And some MSIs are doing it. I'm not saying that those MSIs are perfect or that they're not without any challenges. However, at least they have a structure and system in place that, if given the right resources and support, they will reach their full potential. So I would love to see criteria for meaningful MSIs written into an overall framework to make the few MSIs that truly deliver, to give them a push actually, to double down on the ones that have been working very seriously on advancing human rights in corporate practice through their members. Understanding that it's one puzzle piece in sort of hopefully soon overlapping corporate accountability structures. So generally, I don't think should be an either or question, like do we need legislation or should we focus on voluntary initiatives? Should we focus on a treaty? We need all of that, like all hands on deck. Yeah.
Super, thanks, Dora. And I see there's some activity in the chat, and of course, maybe Ben can, if the panelists are not able, but also introduce links to the chat, Ben, to the the relevant publications. But for any of the panelists, if you have recent publications you're speaking to before or after you've spoken, feel free to post in the chat, because I'm sure the participants will be interested. Now, actually, next I would like to go to David, and some of your very interesting recent work, David, around corporate power and how it affects human rights, and also on economic and social rights, I think also speaks a bit, to the issue of scope of a treaty. There's been various sort of movements over the course of the last 7 years in terms of the scope of along lots of different parameters of the scope of the proposed legal instrument at the UN level. Certainly an area of weakness throughout, although it's been partially addressed, has been the state business nexus, and also simply the regulatory role of the state and state obligations, because given the initial focus on sort of transnational private litigation and corporate liability. So yeah, how does your work, how should your work inform us in relation to these questions?
Yeah, thank you very much, Claire. And as others have said, very nice to see people who I haven't seen for a long time here, at least virtually. So my research recently has been looking at things like provision of socio-economic rights resources through markets, so things like housing markets, food markets, healthcare markets, etc. And then also like wider structures that influence this, so how company law, shareholder primacy, this sort of thing, then has an eventual impact on how businesses are structured, which then goes on to make housing more difficult to access, or whatever it might be. So I come from very much like a traditional sort of business human rights background, particularly during my PhD. But when looking at markets for socio-economic rights resources, I think it's easy to get a little bit disheartened at almost all business human rights type initiatives, because there's not a huge amount of focus on this. I've written a few things about how the UN guiding principles can, in theory, be applied to the question, but I think it's fair to say that when it comes to even something quite direct like US healthcare, there's not a huge amount of sort of normative pressure towards getting proper human rights respect in those insurance companies and hospitals and so on. And if something like housing and complex global food is even more difficult. So this is kind of where I am with business and human rights. And I think probably in agreement with you, Claire, although maybe you disagree, but I think I agree with you here, that the treaty has some issues in it at the moment, the draft treaty. So like one thing that I like when I see it is Article 1.2 that says, to paraphrase, that the scope of this treaty covers human rights abuses defined as any direct or indirect harm that impedes the full enjoyment of human rights. So this seems like an incredibly expansive framing to me. And other people have noted that, like, on jurisdiction and things, it's also very, very expansive. So this is very, very good in a way, but as I know you've written, Claire, and others have said, it does make it unlikely that states are going to sign up to this. So there's always this problem, I think, particularly you've got the non-binding and the binding problem, and then you've got how ambitious you want to be while still creating something that is feasible to sign up to. For my particular issue, not only is it possibly too ambitious at the moment, but there's also a lack of background work being done. For example, most national action plans do not include anything on housing markets, on domestic housing markets, domestic labour markets at all, particularly from developed countries. They just don't see this as their type of problem. Human rights abuses are something out there. They're not for developed countries to be thinking about. So there's this, like, there's a lot of groundwork that needs to be done before this can even properly come into it. And then, yeah, moving on to your idea for a framework treaty, which I think could definitely make some improvements on where the treaty is. It could definitely, assuming the current treaty is too ambitious and also perhaps too vague in places, a framework treaty could definitely move past it. And I think one thing from reading the framework treaty itself and also the American Journal of International Law article, one thing that I thought about would be the possibility of policy review boards being included in this, not too dissimilar to the UN Working Group on Business Human Rights, or a committee, a human rights committee, treaty body. But particularly to look at things like how company law, how investment law, how housing law actually affects access to rights. So something like this in the treaty, either to, yeah, country by country, or one to look at the whole situation, whatever it might be, just to properly look at these and then say, okay, so here's the specific problem with how you constructed shareholder primacy in your company law or whatever it might be, and how there could be human rights responsibilities here or obligations for states to change these rules. That would be very ambitious in a binding treaty. So possibly as like a human rights committee, this sort of thing could just slightly push things along and over the generations become a bit more binding. And I think that's all I need to say. So thank you very much.
Thanks a lot, David, and that was admirably punctual. So yeah, I mean, I think with the framework instrument, of course, one of the critiques that is that normatively it's too open-ended and too thin. There isn't enough specificity to the obligations which are being articulated either for states or the obligations / responsibilities of companies. But to my mind, apart from the issues of getting it across the line and specificity, increasing specificity, sort of diminishing the scope for widespread ratification and adoption, there's also something which is even more important, as it were, which is keeping the sort of discursive space open because of the mercurial character of capital, because capital will seek out new possibilities that none of us probably today would be able to dream up if we think about cryptocurrency and all kinds of other manifestations of a profit-seeking sort of impulse. And what we need particularly to be able to address that is a forum which is based on open-ended norms, which can sort of innovate new standards and structures, which can then be agile and respond to these new issues, these new frontiers of business human rights, sort of as and when they emerge. Because I just don't think we can anticipate necessarily now. Nothing will sort of evolve in a necessarily linear fashion from where we are today into the future, and we want to maximize the sort of governance potential of a UN instrument and associated institutions so that we can be responsive to those, hopefully preempt those in some cases, But keep aiming at what I consider to be a more ambitious structure that can head off these tendencies to subordinate human rights to other interests. So thanks a lot for that intervention. Now, I don't think Rachel has managed to join us. Rachel, correct me if I'm wrong. So in which case I would move straight to Larry Catá to be the final speaker in the panel. And well, Larry, I look very much forward to your thoughts in relation to, the framework treaty proposal, but I'm sure also some reflections on, what we've heard so far today.
Well, thank you very much. I'm going to try to share a screen just to give you some kind of visual diversion. Otherwise, I will put you to sleep. Yay, thank you. All right, so you can all see it. All right, so what I was going to do, this is Doro talked about looking at a big picture. I'm going to be even bigger. In a sense, and the theme is really nicely put out at this front page of the pictures that I'm going to share with you. I'm looking at a framework treaty here within an ecology of regulatory systems, and actually all of you over the course of this conversation really have provided all of the necessary ingredients to understand and really in your own ways to make a very strong case for a framework treaty in a framework treaty context in the ecology of movements that we've been seeing developing with both greater autonomy and greater specificity over the course of the last 20 or 30 years. Now let me see if I can you all can still see the slides, right? Yes? Okay. All right, so I'm going to start with assuming I can move the slides, and I'm not sure I can. There it is. All right, so I took as my starting point our mandate, and that is looking at the links of business and human rights to the governance constellation. And we've talked about various frameworks. My point is that I think that given this constellation, that it's necessary to consider two things and two really framing. Since we're talking about a framework treaty, I'm going to be using the F word a lot over the course of the next couple minutes. It's necessary to frame all of this in two ways. The first is to consider the regulatory framework culture that each of the systems that you all have discussed in some significant detail, the way in which each of those cultures embody a different cultural approach to management, a different set of modalities, and a different set of trajectories beyond the functionally differentiated scope within which each of these regulatory systems function. And then the second thing it may be necessary to consider as you work through all of this is the way in which these regulatory cultures, these modalities, and these trajectories might be coordinated. And it's in that coordination function, and Doro mentioned this as well, in this coordination function, that a framework treaty rather than a displacing treaty, as is effectively the Business and Human Rights Treaty, becomes far, far more important. And in a sense, the crux of the argument, and then you can fall asleep for the next 5 minutes, is that effectively, if you look at the ecologies of governance that we've seen developing over the course of the last 30 or 40 years, a treaty would actually at this point do far more harm than good in the context of seeking to displace that with a normatively mandatory set of rules that may or may not align with these already vigorous, self-reflexive communities, regulatory communities globally that have arisen by and through global production chains rather than necessarily through what I call the ancient and increasingly obsolete systems of international law and international states. So what I'm going to do is say, okay, this is all very nice. So what are the 5 systems I'm looking at? What are these constellations around which a framework treaty ought to move? And I've identified 5. One of them is classical international law frameworks, and including in this case the treaty effort itself, sort of as a species of animal husbandry. The second is the private law of public law. The third is the public law of private law, and the third is the movement from nomos, that is from regulation, the traditional law regulation, to data analytics, and we've seen a lot of that already. And then what is coming, and we see that especially in China, it's become very obvious at the public level, but in the West, within large markets, that is a move from this data analytics governance basis to platform governance. That is a move away from government itself, even within public regulatory bodies, from the old modalities of governance to platform, data-driven, platform-based governance. So I'm going to work through all of this. And the reason for all of this, of course, and again, Doro mentioned this, is the overarching challenge. And this is a challenge that we started with John in 2005, 2006. The whole point of this is, in fact, these 3 people with a ladder and a space is overcoming governance gaps. And the current systems are each in their own way ill-constituted to do that by themselves. It can only be done with coordination, right, and a multiple effort. So that's the idea, that's the image. And so how do you use these traditional mechanisms in a new way? And how do you use new mechanisms in a new way? And so we start with, and I'll just go through all of these very briefly. There's a lot of writing here, and you're welcome to read through it. I'm not going to commit the sin of reading my PowerPoints, for which I will spend eternity in purgatory and then hell, because I know purgatory doesn't exist anymore. International law is, in a sense, when you look at it, it's developed to protect assets. And from a very interesting perspective, when you look at this, certainly the rise of international law from the UN system as well, and a lot of this is heresy, so please forgive me, since the start of the UN system itself, has been developed for a specific purpose, and that is that societies and collectives build wealth. And wealth includes the ability to extract and exploit individuals, and that the whole purpose of international law in the context both of human rights and in the context of anti-militarism and anti-warfare is to ensure the proper breeding and utility, ultimate slaughter when it's necessary in the form of exploitation of these assets, so that what is managed is the way in which those who then manage these assets can then have conflicts among themselves for the purpose of controlling both the nature and tenor of, but preserving the bodies of these modalities of social production and wealth. But international law is becoming increasingly irrelevant as a vanguard instrument because it is precisely focusing on animal husbandry, the human and human rights, rather than on human ecologies. That is the thrust towards sustainability and
Larry, I lost your audio.
Sorry. Can you hear me now better?
Yes,
Okay,
that's good.
Sorry. It's a culturally embedded inhibition on the ability of international law itself, both in terms of its modalities and in terms of its normative cultures, to contribute more than an animal husbandry model. We move from that to the and therefore we have these additional frameworks created. The first that I've talked about is the private law, public law. And here what you have is rule systems as contracts, the state moving out of its traditional realm into the realm of markets. This is something that David has been looking at. We're deterritorializing governance communities, and we're looking at the primacy of the market as the apex space for political expression. This is a world of conditionality and IMF loan agreements, of capacity building, and of public policy through governance, the Norwegian Sovereign Wealth Fund and the control of financing, the World Bank and IMF, and the use of state-owned enterprises from the Marxist-Leninist perspective, where you de-governmentalize the public sector and you have them operating, you project power not publicly in the traditional ways, but you project power, including regulatory power, through private instrumentalities, using the instrumentalities of private law for public effect. We then have the reverse, which is the public law of private law, right? Then, and most of us have been talking about this. A lot of these governmental frameworks that we've already discussed in a more granular way really reflect the outcome of the governmentalization of the private sector and the transformation of the state from a regulatory to a managerial compliance and auditing body, which either is done directly within the organs of state or is done through the privatization and fractionalization of all of these responsibilities. So responsibilities down to the operational sector to create private law regulatory mechanisms through multi-state production chains, and then the rise of transnational auditing and compliance bodies, all of which then have some connection to governmental standards and objectives, but all of which are actually governing at the operational level beyond the state. And in this context, we have really the triumph of private law, and private law to some extent detached from a state, although attached to states as the operative modality of governance in a variety of different ways, through soft law, managerial mechanisms, and then ultimately through the construction of specific operational managerial systems within the organisms themselves. That's all the traditional mechanisms, and that was the discussion that we've had really certainly until about 5 years ago, but we're moving well beyond that, because all of this has given rise to a different set of modalities, a different language with respect to which we now govern, and that language moves us from the traditional sovereign command from the body public to the modalities of nudging based on data-driven analytics. We audit, we comply, we measure. We do not believe in the existence of a thing unless it can be fractionalized to an aggregation of measurable components, which are then rated either against each other or increasingly on the Chinese social credit model, measured against an ideal. The state then retains its political power by creating the ideal and by certifying or authenticating the legitimating mechanisms of compliance and accountability. And Sorcha was great in talking about the way this is already working, and Miho as well, in very specific contexts. But you're really moving to a governance of nudging, grounded in judgment developed by the regulatory effects of rating, of analytics-based ratings, where the regulation comes in both the decisions about what kind of data it is you're going to harvest, what is the nature of the analytics you are going to produce, and then where you draw consequential lines from the analytics, from the product of the analytics that you've created. This is a very new system of governance, which is now incredibly important in the operation, not of the bureaucratic administrative nomenclaturas of public bodies, but within the operating systems of global governance. And then, of course, it's only a small step then if you're moving from traditional regulatory modalities to modalities grounded in data, compliance, accountability, prevention, mitigation, remedial structures, which is our everyday language. It's clear that the coordinating function then moves from the administrative bureaucratic model to the platform. It is the data itself that is the modality of governance rather than the bureaucrat who deals with it. And from this, it's a small step to platforms as the administrative unit, and then from platforms to AI for its efficient categorization and cataloging, subject to some oversight and the huge ethical issues that then are created. This is the future, but we already see it. We see it in the construction of Chinese smart cities. We see it in the construction of platforms that are built by combinations of both users and producers, and then their coordination by and through the states or in the West by markets. I've written a little bit about this, but again, it's fresh and new, and it's not clear how this is moving forward. All right, so that's the world in which we're living. This is the world that the treaty itself must, to some extent, coordinate. And in this context, a framework approach that coordinates these realities, that both recognizes and coordinates these realities, that serves ultimately as the platform, the setting up the constraints of the managerialism of a platform, that probably provides the best hope for creating some kind of unitary approach to this mass of regulatory thrust that has been just erupting over the last 20 or 25 years. And with that, I'm done. Thanks.
Thank you so much. As usual, virtuoso contribution. Thank you. Yeah, Larry. We are actually at time, but I have an extra 5 minutes in my pocket for participants. If anyone does want to ask a question, or indeed if any of the panelists want to respond to each other in the absence of questions, we can take that discussion now. I'm sure many of you will feel the need for a little time to digest what you've heard, because we've had very dense presentations, I think, across the board. Anybody in the audience would like to ask a question? And Ben has posted in the chat some information on our final seminar, which we are actually going to push back behind the upcoming session of the Intergovernmental Working Group, in order to be able to reflect on what's transpired during that session at the end of October. So please, watch this space, and of course we'll try and reach you on social media when we have got a date, time, and panel for that event. Okay, well, I don't see today any questions. And any final closing remarks or questions?
Claire,
yes, your name.
If you allow me, I mean, fascinating to listen to all of you. It's a pity that we don't have time for debate. I would have one question to Larry. Your concept of Birchall Treaty as a displacing treaty, as you just said. Would you also, use the same approach or characterization when we consider the position of rights holders? Would you also say that? And I'm here referring to the UN treaty proposal at Geneva. Would you also say that? Would you also apply this term you just explained to you? And I hope, Larry, that we have a chance to debate this, because it's really fascinating. I would really like to discuss this with you. But would you also refer it like from the perspective of rights holders? Is it really a displacing treaty?
Yes, and in fact, I'm only going to take a second. You've pressed the button that sends me into orbit, and that is the construction as an international subject of this new status of victim, which I find to be human rights degrading in the sense that it strips the individual of agency. But that's a long story. but to that extent, it's enormously displacing in terms of a radical transformation of the human subject.
Okay, a highly provocative note on which almost to close, but I see, Sorcha, you had your hand up, so perhaps last word to you today.
Yeah, it was just unfortunate that Doro had to go, because I just wanted to come back on the MSI point, because I do not disagree with her that MSIs are extremely important, and I think maybe, you know, I think my point was perhaps more nuanced than she was presenting it, and as I see Miho's nodding, because I think she was talking about both of us, and I just want to say, you know, that it's not a binary, it's not an either or, and I think I've spent my entire career saying we need some sort of hybrid approach to regulation, but we do have to have buy-in from states. And certainly in my field, we have to have buy-in from PMSCs. And if you look at the code of conduct, I already mentioned there are only 7 states participating in that mechanism. There are 45 private military and security companies that are fully certified, and there are 99 private military and security companies that are members of the International Code of Conduct Association. There are thousands and thousands and thousands of private military and security companies around the world. So I think I think we have to be honest about that and say that they have to step up, and states cannot abdicate their responsibility at the same time by putting all the responsibility onto business actors. I think that's also a really important point that has to continuously be made, and you see it very clearly with the private security sector. So I'm sorry for bringing it back round to my field, but I thought that was an important point to make.
Yeah, thank you. Thank you very much. Well, I think, you know, to be respectful of everybody's time on the panel and beyond, we will have to end it there. I just want to repeat thanks to those of you who've spoken today. And I think the discussion has been tremendously enriching and broadening of people's perceptions. I hope some of those who are coming to this discussion relatively fresh. It can get bogged down, this sort of treaty discussion in the minutiae of specific provisions around transnational private litigation or how to formulate due diligence laws. But I think it's really enriching for, you know, both scholars, practitioners, and also activists to, you know, to have a chance to take a step back and also reflect on some of the broader context and considerations which we may still want to marshal and bring into focus in the discussion. So thank you very much. Look forward, of course, to continuing to engage with all of you, and enjoy the rest of your afternoon. Many thanks again.